everyone. I'm Badamosa Kaisun. I am the group leader of Group A. Our topic is challenges of criminal justice administration in Nigeria. And I'll start by the meaning of Administration of Criminal Justice Act, AJA, 2015, and it was enacted as a landmark to modernize Nigerian legal system, which was previously split between Criminal Procedure Act, Southern, and Criminal Procedure Code, that's Northern. The primary goals of AJA, they are: it minimizes frequent interruptions and stay of proceedings that stall case, improving how courts, police, and prison work together, and it ensures speedy trial.
Constitutional foundation, the basis of administration of criminal justice Act 2015 is rooted in 1999 Constitution, particularly Section 35, which defines the suspect's rights to personal liberty, and also Section 36, defines the suspect's right to fair hearing. Also, Section 34 also protects the suspect against torture and inhumane treatment. Furthermore, all these provisions are being made, although they have been downloaded.
Challenges of police and investigative agencies are funding, operational inefficiencies, and corruption, which affect investigation, documentation, and ways in which suspects are handled, thereby violating Section 34 and 35 of the 1999 Constitution, which prohibits torture and grants personal liberty. Also violating Section 15 and 17 of the 2015 AJA, which states that voluntary confession should be electronically documented and there should be presence of legal practitioner.
The judiciary is hampered by manual long-hard recordings, which simply means the judge has to write down the proceedings of the court trial, which sometimes leads to overwhelming dockets. Even though Section 306 of the AJA 2015 prohibits stays of proceedings, lawyers sometimes use technicalities like interlocutory appeals to cause indefinite delays in trial.
About the correctional crisis, our correctional centers are overcrowded due to an excess of awaiting trial units. This is caused by the misuse of holding charges where suspects are remanded in custody, despite the magistrate lacking the jurisdiction to try them.
So I'll be talking about the innovation introduced by the AJA in Nigeria, which are the plea bargaining and non-custodial sentence. Plea bargaining is an agreement between the prosecutor and the accused person. The accused agrees to plead guilty to a crime. In return, the prosecutor may recommend a lighter punishment or reduce some charges. For example, a person charged with stealing 500,000 naira admits guilty and returns the money. Instead of a long trial and heavy sentence, the court may give a reduced punishment. Benefit of it saves time and energy. It reduces the number of cases in court. It helps victims to get compensation quickly. So I'll be talking about the second part, which is the non-custodial sentencing. Non-custodial sentencing is a punishment that does not require imprisonment. Instead of sending offenders to prison, the court may order them to perform community service, to pay a fine, to be placed on probation, attend rehabilitation program. For example, a first-time offender who committed a minor offense may be ordered to clean public places for a certain period instead of going to prison. What are the benefits? It prevents overcrowding in prison. It allows offenders to continue working and supporting their families.
Socio-economic and tech barriers. Corruption and poverty remain massive obstacles as many indigent defendants cannot afford legal representation. Furthermore, the lack of centralized digital criminal database prevents the effective offender tracking across the
In conclusion to challenges of criminal justice administration in Nigeria, real reform requires full digitization of court processes and genuine financial autonomy to the judiciary. We must move beyond laws on paper to ensure institutional accountability and strict adherence to constitutional principle. Thank you.